from the 5 steps of any lawsuit, a party can settle at any given time during the lawsuit. That means that you could possibly settle as soon as you file for the lawsuit. Other cases drag on for years and don't settle until right before trial. What mediation is, it's a formal process to try to settle the case. Some folks settle outside of mediation, but I would say a vast majority of cases actually go to mediation to settle. Most local rules require that the parties mediate before they have a final trial in their case. Some local rules, such as Harris County, require that people mediate even before they have a temporary orders hearing. What mediation is, it's a process where there's a mediator or a trained lawyer who helps the parties resolve their differences. What will happen when you go to mediation is you will go to the lawyer's office, that's the mediator, or you'll go to one of the offices of one of the attorneys who's representing the parties. The parties will typically be in separate rooms. In other words, there's no joint conference or everybody sitting across the room of a conference table talking. Everybody will be separated. You most likely won't see your spouse or the parent of your child unless you happen to bump into each other in the hall or go into the restroom or something like that. The mediator will then go back and forth between the 2 rooms and try to exchange offers and settle the case. It's important for people to remember that the mediator is not representing either party. He or she is a neutral third party trying to find a resolution for the case. What people also need to remember about mediation is that it's a confidential process. That means a couple of things. First, you can't go to court and talk about what was talked in mediation. For example, if you have a disagreement about the value of your house, and in mediation you are willing to say, well, my house is worth $800,000. I don't really think that, but I'll agree to that for the purposes of trying to get this case settled. And then let's say the case doesn't settle for whatever reason, and then the case goes to court. The other side can't stand up in court and go, well, time out, judge or jury. During mediation, the husband said the house was worth $800,000. We don't talk about that stuff. It's the same deal for kids. If, for example, the dad says, for the purposes of trying to just get this done, I'll agree that the mom can have primary custody of the children and I'll have visitation. And then let's say it doesn't settle. Nobody can stand up in court and say, hey, judge or jury, during mediation, the husband said that the mom could have custody. All that's off the table. The purpose of that is we want people to make good faith offers in mediation without worrying about it coming back to bite them in court. Mediation is also confidential between the 2 rooms. So what I tell my clients is that the mediator is not going to repeat what you and I are talking about in our room to the other room. So for example, the mediator is not going to go to your spouse's room with your spouse's attorney and go, well, Jake or Brian is telling his client this. Caitlin, one of our lawyers here, is she telling the client to settle along these terms. They're not going to repeat that. Likewise, the mediator is not going to take information from the other room and bring it to us without the other room's permission. Now, of course, if I give the mediator permission and tell him or her, look, I want you to share this information with the other side. I want you to let them know that we have this witness that they may not have thought about. Go tell them that and see if that help gets the case settled. Then the mediator will share information. If you do end up settling your case, you will sign what's called a mediated settlement agreement. Now, you'll notice whenever you sign the mediated settlement agreement, there will be a bold, underlined, and all-caps statement that says this agreement is not subject to revocation. That's actually required to be on the mediated settlement agreement in order for it to be binding. Once folks sign that mediated settlement agreement, and if it has those magic words, you cannot get out of the mediated settlement agreement. I tell people, once you sign this, nobody can wake up tomorrow morning and say, you know what, I don't like this deal. I've changed my mind. I can't believe I agreed to that. It's a very serious process. Once you sign it, you really are stuck. So I tell people, really think about this. Come prepared to mediation, understand that you may have a final deal, and when you're signing, understand that this is the deal to resolve the lawsuit. Once the mediated settlement agreement is signed, it'll get filed with the court, and then either party is going to be entitled to judgment on it. What that means is that you can actually take the mediated settlement agreement, even if it's just a few pages, to the judge and ask the judge to render judgment on it. In other words, or approve the mediated settlement agreement and make it the order of the court. After that process has been completed, the attorneys will work together and draft a court order based on the mediated settlement agreement. For example, if it's a divorce, the mediated settlement agreement may very well just be a few pages of bullet points in a spreadsheet. After the judge renders judgment on that, the attorneys will take that 4 or 5 page document and turn it into a 50, 60 page divorce decree. Same for a child custody order. Even if it's just a few bullet points of what we're going to do with the kids, after the judge renders judgment, the attorneys will turn that into a much larger enforceable court order that will then be signed by a judge. Overall, what I tell folks when it comes to mediation is you need to be prepared to settle your case or make a decision about whether or not you need to go to trial. I also make sure that clients know where the mediation is. You'll get a letter from our office letting you know where to go, and of course to bring a check for the mediator or a credit card if the mediator takes credit cards. We try to meet with our clients before mediation so they're prepared for it, so we're not sitting around all day just getting to know each other and trying to figure out what we're doing. I also encourage my clients to watch this video and come prepared to mediation so that we're more prepared than the other side and more able to make a better deal.